सहायक आबकारी आयुक्त जिला रीवा ने पत्र दिनांक के द्वारा प्रतिवेदित किया कि उपयुक्त कार्यवाही के दौरान वाहन अनावेगत को सुपुर्दगी में दिया जाना उचित नहीं होगा।
Yes, proceedings are pending after the matter was remitted back by the session court. बताइए नेक्स्ट वीक बताइए अगर लिस्ट इन द नेक्स्ट वीक। हाँ उसमें देखो ना पर काउंटर should be reaching somewhere that the final order in the case must have been passed by an act and this said final order is appealable in terms of the statutory provision. बस उसके बाद लिखो list next week. 57. Article 3.
The respondent number 5 to 11 unsolved आ रहा है।
Unsolved.
ये इसमें connected एक पिटीशन और सेम पार्टीज के बीच में 10898/21 उसमें सभी शर्त हो गए।
उसमें अपीयर हो रहे हैं। हाँ उसका नंबर बता दीजिए।
10898/21
लिस्ट along with WP 10898 of 21. Next.
58. RS Rathod. That last time vote is issued for custody.
Council for State prays for and grant this 4 weeks time to file stand list immediately after 4 weeks. Next.
59. Yusuf Kumar is best. 4 weeks.
4 weeks.
2 weeks.
59. 58. हाँ 2 weeks. 59. Yes.
The petitioner is a tenant of the respondents number 3 and 4. He has been running a shop of ornaments in Delhi for a number of years. But on 16/1/2021, 16/6/2021, he received a notice from respondents number 3 and 4. They moved an application before the respondent number 1 and secured an order for demolition of the shop.
Yes.
I made a reply to the notice as well as I instructed the authorities that the shop is doing a business that is not in a dilapidated condition. An inspection therefore be made to see whether it is in a dilapidated condition or not. But my main grievance is since I have been situated in that shop, I was not the party to any of the application made by the respondents number 3 and 4. Neither I was intimated in any of the proceedings. Now, if we see on 17/3/2021, the order was passed and I was communicated after 3 months. So that shows that respondents number 3 and 4 wants to get the shop evicted.
3 and 4 are the owner of the property.
There's no dispute about that.
You are tenant.
I'm tenant.
Is there any litigation is pending?
There is no litigation.
No litigation is pending. No suit is pending. You have not filed any suit for eviction.
No, as per my instruction.
You have filed your reply.
You have to find that out because as per my instructions, I filed a reply, but I was not informed that there is any suit. Because in my reply, I specifically stated that a site inspection was conducted by the municipal authority, wherein it was found that the property is in a valid condition. For giving the permission for demolition in order by me, we have sent a letter to the SDO. SDO has made the spot inspection by the revenue inspector Lajit Lordship. After the spot inspection in Lordship and after submitting the report of by the revenue inspector Lordship, the SDO has given the NOC to us. Thereafter the permission was given by the municipal.
This proceedings have been conducted in his presence or not?
But I am not the party.
Because the owner of the
My grievance is I was not a party of any of the proceedings.
owner of the property has submitted the application for demolition. He has submitted his all documents.
Yes.
And on the basis of the report submitted by the RI, we have given the permission.
On the person
And
who is
there
not
is
there
also the
now.
NOC given by the electricity department, SDO, your lordship.
Yes.
So there is no requirement of the notice to the tenant, your lordship. Because the application was made by the owner.
Each person I could be intimated. NPC section 307.
Where is that application which was moved by a landlord to you?
Lordship, I shall file along with my reply, your lordship.
Where is that application?
I have not received the reply.
Annexure R1, page number 6.
I have not received the copy of the reply.
You have not received?
I have seen it. I have submitted.
दे दीजिए,
दे दिया अभी।
अभी दे दीजिए.
It will be taken after a week or so.
Counsel for the copy of it ऐसा कर दें. Counsel copy of return filed by the respondent 1 and 2.
But is there also an application for vacating the stay that I have moved?
That will be considered on the next date of
They
this.
may find a reply to that if they wish to, because it's been pending here for long.
You have not filed any return.
I find my reply. My reply is also.
Replies also.
I have not received that reply.
आप भी दे दीजिए.
Vacating stay.
Receiving तो है आपकी.
It has been supplied. It is in there. हमने भी दिया है, उसकी भी receiving है, फिर भी हमने दे दिया.
दे दीजिए कि कॉपी आप दोनों. Counsel for the respondent number 1 and 2 as well as 3 and 4 are directed to supply copy of return as well as application for vacating stay to counsel for petitioner within 3 working days. अनि आपने तो दे दिया. Counsel for respondent number 1 and 2 has supplied copy of return to counsel for petition. Counsel for the petitioner praised for and granted 2 weeks time to file rejoinder.
I heard finally after reply.
2 weeks time to seek instructions. Counsel for the respondent number 3 and 4 is directed to supply copy of return as well as application for vacating stay within 3 working days. To counsel for petitioner, list in the week commencing on 30th January. Is there any interim? I have to continue.
Well, if it could be sometime in this 3rd or 4th of February, because I think that time it did not always get it. 15th.
Week commencing 13th of February?
Man.
Week commencing 13th of February. I have to continue till next date of this.
Wait.
Next.
60. Yeah, good luck, man.
Yes. For what?
This petition, it's also rendered as infectious matter because the petitioner relief is to finalize the NID proceeding. And that has already been done and tender allotted to one Mr. Mohammed Rashid Qureshi. And thereafter, without cancellation of this tender, again, fresh notice was published on 14/4/22. And petitioner is fully aware of the fact, despite that this fact has been suppressed by the Honorable Court. In Annexure P4, it is mentioned. This is the representative submitted by the petitioner.
Yes.
Next time some instruction from my client.
The counsel for the state submit that the cause agitated in the petition has rendered or 40 years and as much as. क्या वो पुराना टेंडर कैंसिल कर दिया?
नहीं, इसको फाइनलाइज कर दिया
और दे दिया. हाँ.
दूसरे को
It is contended by the counsel for the respondent that and the tender in question has already been allotted to a third party. उनको इंप्लीट नहीं किया जिनको अलॉट किया.
जिनको अलॉट को चैलेंज नहीं किया, ये केवल ये व्यक्ति है कि इसको फाइनलाइज करें.
And the said award of tender in favor of the third party is not challenged this petition. Mr. Counsel for the petitioner prays for time. Next week?
Yes, Lordship.
List next week.
Thank you.
52. Riani Lala.
Any objection? Rejoinder किसका? State? अच्छा state का. You are appearing for?
on the phone.
Fourth.
Earlier we spoke to Supreme Court for the same reason it was filed.
Huh.
And again they filed out. Earlier they challenged the order, now they.
You filed your return. Counsel for the petitioner praised for and granted 3 weeks time to file rejoinder to the return filed by the state. Counsel for respond number 4 also praised for time. 3 weeks time to file return. List immediately after 3 weeks. No, 2 weeks.
64. So the certain part of land owned by on a certain part of land owned by
Yes.
the respondents they constructed a public road.
Hmm.
Page 11 may kindly be seen.
Page 11. Huh.
The fact that extent of construction of this clear from this document.
Yes.
विषय अंतर्गत लेख है कि ग्राम डोंगर परासिया पटवारी अंक नंबर 100 राजस्व निरीक्षक मंडल परासिया में आपके आदेश अनुसार आवेदक अजय कुमार वाजपेयी दैट इज द पिटिशनर निवासी वार्ड नंबर 100 परासिया के आवेदन पर मौका जांच की गई। मौके में पाया गया कि वर्तमान अभिलेख के अनुसार खसरा नंबर 197/1 रकबा 100 अजय कुमार पिता चंद्रिका प्रसाद जाति ब्राह्मण के नाम भूमि स्वामी हक में दर्ज है। मौके पर पाया गया कि खसरा नंबर 197 रकबा में से 0.041 हेक्टेयर पर सीसी रोड का निर्माण होना पाया गया है। मौके पर बताया कि सीसी रोड का निर्माण नगर पालिका परासिया द्वारा किया गया है। Now in view of this I claim compensation.
Yes.
Page 14 my lord should see.
Yes.
My claim has been rejected saying that there is no provision to pay compensation. Land unless it is acquired or compensation is paid, it cannot be taken away. Now, in the return which they have, the state has, the respondents have filed. Ironically, a stand has been taken that I have donated this land to the state. No document of or particulars of donation have been placed. Page 14, my lord should see, they say
Yes.
page 14, my lord.
Have you implemented with Nagar Palika Parasiya?
This is the
Who
reply
appeared?
on behalf of state and Nagar Palika is supported by affidavit of CMO.
Okay. What is your stand?
Well, our stand is that, first of all, the petitioner is coming to this High Court after the lapse of 11 years. He was well aware about the construction of the road. It has been constructed way back. And thereafter, after more than 11.5 years, petitioner having all the knowledge and he came to this honorable court. Now, regarding the proposals and all the proceedings, we have filed the note sheets with our reply. R2 maybe similar. These are the note sheets which have हर जगह बोला है कि क्या प्रोसेस हो रहा है उसके लिए रोड के लिए. This was done way back. This time the petitioner was non-null. When the construction was made, the road was in working condition.
What is your reply to paragraph 3 of their return? They say that you donated this land.
There is no document to that effect.
But still, this is government on affidavit. This needs to be dealt with by the court. Because there, yes.
Because
Counsel for the petitioner contends that there is an incorrect government in paragraph 3 of the return to the effect that the land in question was donated by the present petitioner in favor of municipal council Dungar Parasiya.
yes,
Dungar Parasiya, whereas and the petitioner never donated the said land. Counsel for petitioner from praise for time to file rejoinder. The reply filed by this respondent. Time granted list after 2 weeks. 2 weeks. Right. Here for respondent,
yes,
none for the petitioner. Your Adit Narayan Sharma, Shri Adit Narayan Sharma for respondent.
Single response.
For the respondent, list after 2 weeks.
My submission is that recently had 5 million. There is a recovery of 25 lakhs and in petition.
List in the week commencing 23rd of January.
March.
Yes.
66. Parimal Chaturvedi.
None, 2 weeks.
57. Vijay Shankar Pandey.
None, 2 weeks.
58. Amit Kumar Tiwari. The reply of the estate is related, madam. The reply of the private respondent has right. But the state reply.
The state is contesting. Contesting respondent. Counsel for the state praise. Yes.
MP है इसी के साथ 505 और 20 तो एक निवेदन था कि इसके साथ लिंक किया जाए क्योंकि दोनों एक ही एडिजे ऑर्डर का प्रॉपर्टी भी एक ही थी.
No, in this case, madam, we have changed the order issued by the board of brigade. So they have defined. Let me reply at the step.
उसमें दूसरी में कनेक्टेड में क्या है? किस ऑर्डर को चैलेंज किया?
ऑर्डर एक ही है.
नहीं, ये इसमें तो कह रहे हैं बोर्ड ऑफ रेवेन्यू का है, आप कह रहे हो कि डीजे का ऑर्डर.
दोनों एक रिलेटिव हैं, चाचा भतीजे हैं, प्रॉपर्टी भी एक.
नहीं, what is under challenge in this petition? Order of board of revenue is assailed here in this case.
In the order of
Board of revenue. The state is contesting or this private respondent is contesting in this case? Who is contesting party? In this case, you have filed return in this case. You have filed reply in this case.
रिप्लाई है 2 and 3 के तरफ से.
File करके. हाँ, तो if the state is not contesting, then you argue.
the respondent to has filed reply.
हाँ,
So the reply of the state is a bit.
the state is reply. State is necessary or not? हाँ, तो then you argue. लाइए file.
पास ओवर का देखिए शर्मा जी ने
You are prepared. You are prepared to argue. You are not prepared. At the joint request of the parties, list after review. Next.
But 69. Central Future.
69.
For short time to file rejoinder and this is have obtained certain documents under RTI to place them on record.
Any objection, Mr. Counsel for the petitioner, please for and granted 2 weeks time.
2 weeks time.
To file rejoinder list after 2 weeks. Next.
For 70. Brijesh Kumar Dubey.
70.
70.
None. 2 weeks.
71.
The 70.2 have, this has become a success.
70.2.
So I am for the, also I am for the interview. Mr. Kishan is not here, but it was temporary permit for a specific purpose, time. That is 28 to up till 28 February 2022. That period has expired. So this has become a success.
Who appears for petitioner?
Rajesh Dubey.
Password कर दीजिए. Password.
$71.
I'm appearing in behalf of respond number 1.
None for the petitioner. Counsel for number 1 and 2 praise for and granted 3 weeks time to file return. List immediately after 3 weeks.
2. The event started.
Counsel for state praise for and granted 3 weeks time to file return. List immediately after 3 weeks. Next.
73. Emergency.
None for the petitioner. List after 2 weeks.
74.
7, you are appearing for respondent?
They have already filed a reply to that one.
You're appearing for which date? 10th?
9th or 10th.
Yes, Mr. Lal.
For the State Department. That's the week of 16th.
Any other fixed date in week commencing 16?
After 3 weeks, because 16 to 18 senior is not available.
16 to 18 not available.
I should think.
Then let it come in the week commencing 23rd, any other day? 24th? At the request of counsel for the respondent, call on 24th.
No, I heard.
If I need to continue till next date of listing. हाँ 24 जनवरी.
Fine. Kumar Yadav.
है कोई? नहीं, none 2 weeks. 26.
76.
ज्ञानेंद्र सिंह बघेल.
Joiner please करना चाहेंगे.
Yes.
Yes.
Counsel for the petitioner prays for him granted 3 weeks time to file rejoinder. List after 3. As कोई interim relief है?
नहीं कोई इंटरव्यू
नहीं. List after 3.
77.
77.
Kumar Mishra.
Yes.
What about this matter? 70,000 replies for the record and 77.5 other. Other matter the reply is fine.
77.5 में reply नहीं.
Yes, sir. I'm 77.
77 and 77.5.
The MAC is replies already been received. So only
You wish to file any rejoinder?
no.
Hmm.
The only point involved in this all this petition is what will happen in this case, the one Samru who sold the land after taking permission from the collector.
Hmm.
And that was in the year 2010.
Yes.
Now sub-divisional officer exercised the suo motu power after about 12 years without giving any opportunity of hearing or without giving any show cause notice, cancel the name of all the persons.
All these petitions are affected person.
Yes, all they were not done.
Reply तो सबका एक से stand तो एक से ही होगा. So you can adopt the return which is filed by in other cases also.
In fact, in my case, the return was adopted.
Return is here.
Yes, return is there. Stay is there, but they have not said anything about that. Whether opportunity of hearing was given or not. This is the only point.
Then you argued finally if you have already filed a return. Counsel for सदत किस में फाइल नहीं है आपका?
77 and 77.5.
77.5 में कर दीजिएगा. Counsel for the state prays for and granted 2 weeks time to file return or to adopt the return already filed in the connected case. Yes, sir. List in the week commencing 23rd of January. I have to continue till next date of this.
28. My lords, only 2 minute issues involved. My lords permit me to argue. I'm only playing for a remand.
Yes.
In this case.
Dikhai.
My lords, a very small issue is involved, my lords.
Yes.
What happened, my lords? MP Chess Association, without opening the file, I just gave a summary.
Yes.
MP Chess Association was affiliated to All India Chess Federation.
Yes.
Now, All India Chess Federation,
Yes.
they were recognized by the Union of India as the official body for the game of chess.
Yes.
So, my lords, we were affiliated to AIC as All India Chess Federation.
Yes.
Now, my lords, apparently some people come playing against us, saying that we are not performing the duties properly. Now, my lord, on account of this complaint, and it is admitted fact, without affording us any opportunity of hearing, the charge, the recognition that was granted to us for conducting the activities of chess in the state of MP,
that has been cancelled.
That has been taken away and given to the complainant.
Complainant is a party here?
Yes, complainant is a party. So, my lord, this is the entire case in a nutshell. Now, my lord, in the return, there is a singular point involved, rather 2 points, my lords. First is, my lords, they say that.
Where is that impugn order by which recognition has been?
Yes, my lords. My lords, there are 2 impugn orders. One is for the recognition and second is for the charge that is handed over to the complainant.
P9.
There was an P9. There was one is P9, then second one is P10.
Hmm.
P9 is the disapplication and P10 is the taking away of charge and handling it.
Some ad hoc committee has been constituted.
Yes, my lords, and these ad hoc committees constituted with the complainants only. And they were the ones to highlight some serious irregularities, completely ex parte order. At no point of time any show cause was issued to us, or we were never called for the hearing also. Now, my lords, what they are saying in the reply, and why I say only a singular question of law is involved here.
Yes.
My lords, in their reply, they are saying that number one, there is an alternate remedy. Because as per the bylaws of AICS, the courts of Delhi will have jurisdiction, the civil court.
Yes.
And number two, my lords, what they are saying is that we already filed a civil suit in New Delhi on this very issue, and that is why this petition is not maintainable.
Yes.
So, my lords, my humble submissions on those 2 points, my lords. First, my lords, that if it is an admitted fact that the principles of natural justice are violated, so my lords, writ jurisdiction is made out in this case. As no show cause notice is issued, and my lord, there is clear minor fights as the complainants are directly given the charge. And my lords, as far as the most important aspect is concerned regarding the fact that we filed the civil suit, and my lord, this was also brought to the knowledge of this honorable court by the respondents. One of my submission to that is we have never filed the civil suit. What actually happened, my lords, was that a person who was not authorized, his name was Amit Soni.
Yes.
So, my lords, he goes to the Delhi court and he is in conspiracy with the private respondents here. So, he goes to the civil court of Delhi.
Yes.
And, my lords, he signs on a paper saying that I am authorizing myself to file the civil suit.
Yes.
So, my lords, he played a fraud on us. And, my lords, in the letterhead also, I will just show all the documents one by one. I'm writing the adverts, my lords.
Yes.
My lords, in the letterhead of the MP Association, it says that the president's name is there and the secretary's name is there. So this person forged his own name into the letterhead as the treasurer, and he is subsequently removed also. And my lords, to file this WP also, my lords, there is a board resolution that we want to file this WP. So he had no board resolution also. In one page letterhead, he simply wrote that I am authorizing myself to file this case.
Yes.
And he filed the civil suit and he has forgotten about it. So, my lords, my humble submission to that second aspect is, my lords, any proceeding that is initiated by fraud or without any authority of law is a nullity in itself. And, my lords, it can't be said that the association has filed a parallel civil suit in Delhi and is now gambling by also filing a writ before this court. So, my lord, as far as this aspect is concerned, there is only one question of law involved here. And that question of law is, my lord, that whether a civil suit filed by a person who is not competent to do so will be counted as a duly filed suit or not. And
this question will be decided by the court of Delhi, not in this petition. Whether the suit is maintainable or not. You raise this objection before the Delhi court.
because we have already raised.
Yes.
We have
You
already
raise
raised.
it there. That issue cannot be decided here. In this petition, that a suit which is filed in Delhi is maintainable or not.
Yes,
That is for that court to decide this question, not this court.
Your Lordship may in that case pass an order directing that Your Lordship may simply adjourn the case with the liberty that we may move an application of listing after the decision of that suit. So, my lord, then
It will take here together. You withdraw it, you contest the civil suit. That liberty will be there to revisit the
the
court.
only issue is we did not file the civil suit.
You get this issue decided by the court at Delhi.
Then Your Lordship may grant us the liberty to file it afresh after that issue is decided.
Yes.
Before that, Your Lordship, my lord's comment. But I would just like to bring something on record here. So far as the disaffiliation part is concerned, my lord,
No,
apart
he
from the court
is
settlement,
withdrawing his petition with liberty. Why you are opposing that?
but in fact, they are not even entitled for the liberty part also. That is what I am submitting, my lord, because we appealed line before the ethics commission. That
The
is
liberty you cannot oppose. That is always his right to file. He can file repeated petition. You cannot. There cannot be a blanket order not to file any petition. Counsel for the petitioner prays for withdrawal of the petition with liberty to revisit the court from if cause of action so arise.
The workshop will also write the line pursuant to the civil suit pending at New Delhi.
With liberty to. What?
Pursuant to the procedure.
In view of the ऐसा कर देना, in view of the filing of the civil suit in Delhi, counsel for the petitioner pays for withdrawal of the petition, he has liberty to revisit the court if cause survives. Cause of action arises.
The lordship may also act pursuant to the outcome of civil suit that line with the application.
That will create a bar for you. Suppose the suit is pending for 10 years.
Yes, madam.
Then you won't be able to come to court 10 years, for a period of 10 years.
The lordship may also then grant me the liberty to move appropriate application in the civil suit.
That is your liberty.
Your
उसमें ऐसा करते हैं, counsel for the petitioner contend that the suit which is filed before the Delhi court is not filed by a person competent to file a suit. Therefore, that issue needs to be adjudicated. Thus, counsel for the petitioner pays for withdrawal of the petition with liberty to file appropriate application before the court where the suit is pending. Accordingly, the petition is
And approach this court for the further
dismissed and also approach the court
for further cause of action.
after the proposed adjudication of the issue, which is
Approach this court.
which is
Your lordship may observe this court.
after the proposed adjudication of the issue is to be raised by the petitioner before the Delhi court. Accordingly, the petition is dismissed as withdrawn with the aforesaid liberty.
Just one more observation, minus the time with this.
Yes.
The court has not committed everything on the merits of the case, and that court at Delhi at liberty will have to decide the same.
Not
So far as
necessary.
the application for intervention parties concerned, I'm only on that issue.
No, he is withdrawing the petition with certain liberty. That is granted to you. There is no opinion by this court on merit.
So if there is this observation, because they have been directed to approach the authority before the court at Delhi. So my submission is, if times it happens that the same may cause prejudice.
He is withdrawing a petition with liberty to move from appropriate application before the Delhi court, saying that the plaintiff is not competent to file that suit. That's all.
Only the merit part may be directed. That is the only.
No necessary, no. It is simple withdrawal, innocuous order. It will not affect you any.
I'm okay.
79.
79.
On behalf of respondent number 2 be marked.
हाँ इनका number 2 के लिए इनका
Class.
class है.
Lordship, I request 2 weeks time to file rejoinder. Responding number 3 and 4 has replied.
Counsel for petitioner pays for 3 weeks time to file rejoinder. List immediately after 3 weeks. Next.
For 80. Complete Kumar Gupta.
The Lord, it is a contempt issue for the compression appointment.
Hmm.
The reply on the government side is there.
Huh?
We want to file a counter.
Counsel for the petitioner pays for time to file counter to the compliance report filed by the respondent. 2 weeks time granted. List immediately after 2 weeks. Next.
81. We can't get that.
Yeah.
This month I'm going for 3 days time to this certain documents on the body.
Any objection?
No, before 20th of January matter be listed because.
Counsel for the respondent, prays for. You have to file reply or bring some document on reply.
The documents on record. Reply is not required.
For
227.
prays for 3 days time to file some relevant documents which according to counsel are necessary for proper adjudication of the matter. Time granted. List on 17th of June. Next.
Number 82.
Yes, any objection?
No.
Your appeal? IRs there?
Yes, sir.
Counsel for the respondent prays for and granted 2 weeks. 2 weeks time to file response. IR to continue till next date of list. 83.
Okay.
Yes.
Reply is signed out.
Filed. Copy दे दिया copy. Counsel for state is directed to supply copy of return to counsel for petitioner within 7 working days. Counsel for the petitioner also prays for time to seek instruction as regards the reply. Time granted. List after 2 weeks. IR if I need to continue till next date of meeting.
For 84.
Hearing in booking number 5890 of 2009. Short part is in 1 minute. But I didn't heard about it. It's a petition of 2009.
Yes. You are not prepared. What about the other case? Who appears
In
for
fact, the facts and circumstances of this case is a bit different from the others. I'm only saying that this matter may kindly be taken and any date as per my friend's request may kindly fix.
Can it be dealing? Matters are not identical. What about these
A
other?
little bit different.
Yes.
Others are also not appearing, but that's fine. I'm interested, Manoj, because this is a petition of 2009. Short fund is involved.
You argue then next date. Even if the otherwise no one appears in other cases, you argue this one. You are not for respondent in other cases. In all cases.
On behalf of society, Manoj, he is appearing in all cases.
All cases. Counsel for the respondent before, comma. Submit that he is not prepared to declare for praise for a short adjournment, comma. List in the week commencing 16th of January. It is made clear that no further adjournment shall be granted to the respondent on the next date of list. Yes. Next.
But this petition we can't use it. Others are also not interested in getting this decided. That's in case the appeal, then
Let it come on the next date. Even if no one appears in other case, you argue your case, it will be decided.
previously, Manoj, also in connected cases, no one.
No, it is being adjourned only for the request of number 4. Suppose he is prepared to argue today, it can be decided today itself. Your case.
Right.
So it will be decided on the next date, provided even if the otherwise the other counsels are not there in other cases.
Right.
Next.
85. Yes.
85. Yes. Odd war. Yes.
Respondent number 3, okay. Find the application IA application for the recording of the order dated for 23/11/2022 notice. 8/12/2022 was the document code. You will notice in this IA notice, there is no specific in this compliance report notice. There is no specific disciplinary notice, and no remark of the president of the business and not mentioned in the compliance of the reporting document.
They have filed a compliance report.
Note it. I number 15/7/6 only.
Yes. So what is they have already decided it. Why this annexure R2? If you are agreed, you can assail it. Because the order was innocuous, it was not on merit. They were directed to take decision. Now they have taken decision. Why the annexure R2?
This I filed by the respondent number 3 notice by Collector Satna notice.
Yes. This is IA for recalling.
Notice.
What do you have to say about the what you have to say about this compliance report? It is complied with or not? The order is complied with or not?
Not notice.
How do you say that? It was an order to take decision. तेरह दिसंबर को अभी 13 तारीख पेमेंट तो कर दिया आपको?
नहीं किया। नोटिस इस पे ये भी क्लियर नहीं है नोटिस कि कितने मंथ का ये विड्रॉ कर रहे हैं।
इसको आप एजिटेट करिए, ये क्वेश्चन नहीं था कि कितने मंथ का कर रहे हैं।
अभी तक तो नहीं किया बच्चे। अभी मैंने सुबह ही इसका
पेमेंट नहीं हुआ है,
नहीं हुआ।
ये सैंक्शन हुआ भी कि पेमेंट हो गया?
प्रपोजल
सैंक्शन हो गया, इसको कर लीजिए। The response number 3, submit that an application wide IA 15769 of 22 has been filed seeking recalling of order dated 23/11/22 and 8/12/22 by which this court directed the response number 3 to remain personally present before this court. It is contended by the counsel for response number 3 that the order passed by this court in WP number 17831 of 2020 has been complied with and a compliance report has been filed by IA number 10207 of 22. Thus submit that the orders dated 23/11/22 and 8/12/22 be recalled. Stop. It is contended by the counsel for petitioner that an share of the payment pursuant to Annexure to those sanctions have not been made to the petitioner as yet. List of counsel for the respondents and the payments shall be made to the petitioner the moment the sanction is accorded. Sanction has not been given. ये sanction के लिए तो भेजा है ना? The moment sanction is accorded in view of the additional compliance report and also the Annexure to come. The order dated 23/11/22 and 8/12/2021. So far as they relate to the personal appearance of respondent number 3 are recalled. Respondent number 3 is exempted from appearing personally before this court. List in the week commencing 23rd of January. Awaiting further action initiated on the strength of communication dated 13/12 by content and Annexure.
What
the esteemed George. Yes.
Well, this is the first bail application under section 438. Offense is 25(1)(b), 531 arms act madam. But इसमें क्या हो रहा है ये co-accused बना on the basis of main accused. Main accused already granted benefit of bail before this honorable court madam. 16/9/2020 को ये होता है उसके happen होता है मतलब फिर 18/9/2020 को ये arrest हो जाता है और उसको जमानत भी मिल जाती है जेल में। मतलब चालान पेश होता है 17/11/2020 को, तो इसमें 31 जोड़ी जाती है, तो वो दैट 31 पे हमने ये 438 लगाया। Main accused already granted bail before the honorable court on 22/12/2020. That is election.
You have been granted bail.
Yes.
Earlier, he was granted bail by the trial court on being arrested. And because after filing of challan, subsequent sections have been added. As a wounded person, they have filed this application.
31 arms act जोड़ दिया गया, that's our knowledge.
The other 40 person उसका record थोड़ा कम है, इनका record थोड़ा ज़्यादा
ज़्यादा है, आपके पास डायरी है?
But A2 लगा हुआ है, so accused already granted before.
No, he was granted 439. He was in jail.
बट मैलॉट हाँ हमको बेल ग्रांट हो चुकी थी मैलॉट, और जो हमारे पास रिकॉर्ड है उसमें एक्विटल भी हुआ है मैलॉट, उसमें आया भी है।
क्या है इनके खिलाफ क्या है?
There are 5 cases of arms act and another 2 under IPC. One is in Maharashtra, one is in Andhra Pradesh. So he is a supplier of illegal arms. That is the idea.
डिस्चार्ज
इनसे भी कट्टे जब्त हुए हैं. There is seizure from him also.
All cases are pending or decided? एक में सजा पड़ी है, एक वापस हुआ है, एक कुछ कुछ में सजा पड़ी है मतलब, और कुछ ट्रायल में है, 2 में छूटा है, 7 में से 2 में छूटा है, बाकी में सजा पड़ी है और ट्रायल में।
only on the basis of memorandum, है?
नहीं, कब्जे में 4 में देसी पिस्टल, एक रिवॉल्वर, एक देसी कट्टा, ये रिजवान से मिले। इस कन्विक्शन इज देयर, अर्लियर कन्विक्शन इज देयर, एंड अर्लियर कन्विक्शन इज देयर मतलब अंडर आर्म्स एक्ट। आई विल पॉइंट आउट मतलब ये 108 बटे तो 31 तो आपने अप्लाई होगा, दैट बेल वाज ग्रांटेड टू द co-accused as there was no prior conviction earlier, therefore 31 was not applicable. 31 only comes into play when there is a prior conviction in any other case. That fact was considered, then he was enlarged on bail. तो आप प्रोड्यूस कर दीजिए, because it ultimately say that once he is convicted, then section 31 has been rightly. Serial number 1 and last one. हाँ, सजा है ना 3 साल के लास्ट वाला। नहीं, the considerations were different. Against him, offense under section 5 and 31 was raised. Subsequent offense, and there is a previous conviction, then 31 will come into play. In that case, there was no previous conviction. कन्विक्शन नहीं हुआ, नहीं है उसका रिकॉर्ड है, वो ऑर्डर में आया, वो भी टाइम में लगा, कन्विक्शन नहीं हुआ। You can examine this, then argue. You see that in your case there is previous conviction, right? And this is an anticipatory bail application. He was granted 439. So you cannot claim parity with the co-accused. Now this section has been rightly, this 31, because there was a condition imposed. This section 31 was not there earlier. It has been subsequently.
Condition imposed कर दीजिए, हम ready to 15 days या month की हम खाने की वो भी any condition imposed. हम investigation में भी पूरी
No, you can always not anticipatory bail. Your case can be considered under section 439, but not 438. As there is already a conviction, and as many as 7 cases are there again. Interested of
looking to the co-accused, same
you appear to be dealer.
Submission is there, looking to the co-accused, same day का भी अगर order हो जाएगा तो same day
that even the question of parity will only come into play when there is an application under section 439. His application was under section 439. He was in jail and no previous conviction. In your case, there is previous conviction and you are seeking anticipatory. Decision is yours. Withdraw it or you want an order on merit.
Withdraw with convictions या withdraw with liberty की same day consider करें तो हम surrender करके फिर same day consider. I'm ready to same day consider.
Counsel for the petitioner placed for withdrawal of this bail petition with liberty to surrender for the court bill form and also apply for regular bail. Instead, it is contended by the counsel that the court will be directed to consider the bail petition same day on which the same is submitted for consideration by the present application is dismissed as withdrawn with the aforesaid liberty, it is expected that the bail application, the proposed bail application to be moved by the petitioner shall be considered by the court as expeditiously as possible. No fixed date can be given. You वापस करो।
The last order sheet, like I was given the liberty to file a fresh application. Now, my lord, the application has been filed by the wife and the daughters also. My lord, so they should not have any objection.
Yes.
No, not this.
Nobody. Where is that IE?
This IA is 17297 of 2022.
Is it on record?
When have you filed that?
Yeah, this is filed on.
दिखाइए application देखो.
Hey. One 72447.
Nine.
Is it 97 or 47?
47.
इसमें क्या daughters भी हैं?
172. Only daughters.
Wife and daughters.
No, wife and daughters and Vakalatnama is also there.
On IE number 17247.
No, 47.
47 of 22, which is an application filed under order 22-3 CPC. For the legal representative of deceased petitioner on record of due consideration, the same is allowed. Let the legal representative of deceased petitioner be brought on record and cost letter be amended accordingly.
Within 7 working days. 3 working days. Within 3 working days. Please tell me. Is there after? It is being listed for handling that motion statement, but can you be listed in the week commencing 16th? I have amended the petition. I'm going to file reply after amended 2 weeks time. Which amendment? Earlier also you amended petition. But I have filed the rejoinder also, and they had way back here, you had proof of nice over a copy, they were supplied, and in September I filed the rejoinder. You wish to file additional return? That's, you are appearing for which respondent? Respondent number 2. Number 2? 2020 में time counsel for the respondent number 2. Also prays for 2 weeks time to file the rejoinder to the additional return to the rejoinder. The rejoinder counsel for the petitioner submit that rejoinder was filed with the कब file किया था? In September 2020. 22. Rejoinder was filed in September 2022. Copy नहीं है आपको? And an additional copy of the rejoinder shall be supplied to the counsel for respondent number 2 within 3 working days. List in the week commencing 6th of February. It is made clear that no further adjournment shall be granted to the respondent number 2 on the next date of listing. You come prepared on next date. Please see, आइए बुला लो. Next. Apology for making out of turn. Yes. I was the item number 78. I had late for withdrawal. You were not sure about to dismiss the case on that point. Yes. My sincere apology. I made a statement to withdraw, but the client wants an overall payment. I will not repeat the name. Not sure to dismiss the case as not maintainable on account of the fact that civil suit is pending. Even we have to not take it. Why is that? No. Item number 70. जो और लिखवाया है ना उनको बोल देंगे. The respondents have taken an objection that civil suit has been filed by the petitioner for the Delhi court, and as from on the suit is already pending, the present petition is not maintained. Then your submissions are not being recorded. Otherwise, that will as the civil suit has already been filed. This may be recorded that we are also filing the application and contesting if it's maintainable or not.
Because that permission has been granted because you say that suit is not by competent person.
Yes, my lord. Yes, lordship may take up with that. We are already contesting in that suit by filing the application.
So that submission should be there in the order sheet or not? Because in the withdrawal contains that your statement that the suit is by an incompetent.
Yes, my lord. It is.
So that contention should come here also.
Yes, madam.
Counsel for the petitioner or contra counsel for the petitioner contend that the suit has been filed by a person who is not competent to file a suit on behalf of the association.
Yes.
And of the association, and as much as there is no resolution in his favor.
Yes.
No resolution in his favor. That's right. Next paragraph. Upon appreciating the efforts of contention, comma, the issue as to whether the suit is by a person competent, the suit is at the behest of the the suit is maintainable or not, and the person who is incompetent is an issue is to be dealt with by the concerned court. Thus, in view of the filing of the civil suit, the issue is to be dealt with by the concerned court. Thus, in view of the filing of the civil suit, the filing of the aforesaid civil suit, no interferences warranted at this stage. Accordingly, the petition stand dismissed.
ऐसा ये कर दो, बता देंगे उसको. 88.
88. हाँ, कब खारिज हुआ?
उनके 11/2022 को खारिज हुआ है.
क्या this is an application seeking restoration of FA number 1531 of 22, which has just been dismissed for non-compliance of preemptive order dated 4/11/22. List of contents that there was an order of payment of process fee within 7 working days, which could not be complied with inadvertently.
It is contended by the council that there is a bona fide delay of 6 days in filing of this application. नीचे कर देना. Upon taking into consideration the contents of IA number 15871 of 22, which is an application for condonation of delay supported by affidavit of the council, the same is allowed the list unknown next fire. Upon taking into consideration the contents of application for restoration, which is also supported by affidavit of the council, the same is allowed subject to
process fee दे दिया नहीं दिया?
अभी subject to compliance of order dated 4/11/22 in FA number 1531 of 22 within 3 working days. Within 3 working days. Office directed to verify the factum of compliance of order dated 4/11/22 in FA number 1531 of 22 with the aforesaid and so this is allowed dispose. 3 दिन के अंदर दीजिए पी 3 working days का संडे आ रहा है.
89. ERP to be.
Non-compliance of court order. Petition was disposed of direction to consider the case of petitioner.
When this order was communicated? C2?
It was communicated in page 10.
Yes. Notice. Next.
For 90.
9.
Jason Guru.
One of those MCC for distribution of time number 377/2032. It was this one 6/12/2022. Continue see the page number 1. And it's a
This is an application seeking restoration of MA number 3771 of 22, which has been dismissed for non-compliance of common conditional order dated 17/10/22. First of council contend that there were certain defects pertaining to deficit court fees and also regarding condonation of bill application, which could not be cured within the stipulated period of 6 weeks inadvertently. On taking into consideration the contents of the application, which is supported by affidavit of the appellant number 1, the same is allowed. Let MA number 3771 of 22 be restored to its original number subject to removal of defect within 15 days. Within 15 days from today, office is directed to verify the factum of removal of defect. Therefore, said MCC allowed disposal. Next.
91.
91. Or of Srivastava.
91.
None. 2 weeks.
92. Something
Yeah.
As paid by counsel for petition, list after the week. Next.
93. ABC.
None, 2 weeks. Yes, 94.
94. BP to wait.
With copy of petition. Copy of petition is not with you. You are appearing for which respondent? Number 5.
Caveat not filed, therefore not punished.
श्री आपका नाम श्री आनंद त्रिपाठी enters appearance on behalf of the respondent. Number 5. And submit that the petitioner be directed to supply a copy of petition. नीचे कर दिया. Counsel for petitioner is directed to supply a copy of petition to Shri Tripathi within
Today I saw.
during course of the day. List next week.
95. Delhi Supreme Court.
Action has been taken against me for alleged illegal colonization.
Hmm.
And by the action has been taken against me for alleged illegal colonization.
Yes.
And by the interim order, a direction has been issued to register FIR against me.
Where is that order?
That is, my lord, it starts at page number 34, relevant part is at page 38.
Is it available?
No, it's not.
Under what provision it has been
This is
passed?
under the 1998 rules. There have been several petitions filed in different order. Similar orders are filed at page number 41 onwards.
There has to be provision of appeal.
There is no. It's not available. I'm verified.
You verified?
Yes, yes.
Yes.
Not available.
Not available. कहाँ where is that order by which? अच्छा ये है page 39 पे. Counsel for the petition contents that on the strength of interim order there is a threat for registration of first information. There is imminent threat of registration of first information report against the petitioner, which is further contended by the counsel. Now almost identical cases. The coordinate benches, contact benches has granted interim protection to the petitioners therein. Void order dated 16/11/22 in WP 19472 of 22 and order dated 18/7/22 in WP 14494 of 22. Page number 41 पे है, देख लेना. नीचे गए थे ना, ऊपर कर issue notice PF 7 days, returnable 4 weeks. While maintaining parity, the operation of the order dated 11/11/22 contained in
Section 6.